Welcome to the North Idaho College Public Forum. We're continuing our 2-month series on human rights. These programs are dedicated to the Kootenai County Task Force on Human Relations and their 25-year history working with others for human rights in the inland Northwest. Last week we did Program 1, and it was our responsibility to talk about the struggle for civil rights in the United States. That was our historical background. And as we have finished that, we now want to talk about the movement from the South and how here in the inland Northwest and all over the Pacific Northwest there has been a struggle against hate and promotion of human rights. On today's program, Part 2, we're going to talk about the years 1980 through 1983 of the work of the Kootenai County Task Force on Human Relations. This was taped 14 years ago, and then on the program number 3 next week we'll use the years 1984 through 86. And on the 4th program, we'll deal with the years 1987 through 1991. All 3 of those programs were taped 14 years ago. Then on programs 5 through 9, we will bring you through 1992 through 2005. I hope you enjoy this series. And now we will look at 1980-83.
Idaho, a land of quiet splendor, where the mountains rise and fall in forest green cascades, and the lakes and the sky echo one another's clear blue colors. Set in this natural arena of beauty, Coeur d'Alene has been called the jewel in Idaho's gem state. In 1970, an invasive element arose and threatened to rob her of the inner harmony that had always matched her outer beauty. Racism, with its senseless violence and tragic history, reached for a handhold in the foothills of North Idaho. This is the story of how one community responded to the threat within its midst. When threats erupted into violence, this community learned that you can stand up to hate groups by saying yes to human rights. The hate group that awoke the small town of Coeur d'Alene was made up of white extremists from organizations such as the Ku Klux Klan, the Posse Comitatus, the Neo-Nazis, and the Identity Movement. Locally, the group was known by a variety of names: the Church of Jesus Christ Christian, the Aryan Nations, the Brotherhood, and the Order. Larry Broadbent, the former undersheriff of Kootenai County, has compiled an extensive chronology of the activities of these groups. He now describes the early acts of violence and racism that were attributed to these white supremacists.
In the spring of 1973, Richard Butler moved to Idaho from California. At that time, nobody realized that he had fled from the scrutiny of law enforcement, having served as an officer in the Christian Defense League, which is now known as the Christian Patriots Defense League. During the mid-1970s, Butler formed a local Posse Comitatus chapter in Kootenai County, Idaho, declaring himself the Marshal. After a series of minor brushes with the law enforcement and the courts, the posse quickly dissolved. As one ex-member commented, the reason he was leaving is he felt Butler was building his own private army. We should have heeded that warning. In 1979, Butler refound the Church of Jesus Christ Christian and made the Aryan Nations its political and activist arm. By 1981, the Aryan Nations held its first conference, which unified the Knights of the Ku Klux Klan, both in the United States and Canada. It was because of that meeting we began to monitor the buildup of extremist members, and because of the violence connected with the Klan, throughout its 100 years of history. It was this type of event that the victims that it produced that provided the catalyst to form the task force. Eventually, the task force activities broadened considerably. By 1983, these events had taken place. The militant stockpiling of weapons, recruitment of ex-felons, anti-government statements and actions, territorial imperative, that was the establishment of the white Aryan homeland in the Northwest, and the malicious harassment towards minorities.
It was in response to an incident of malicious harassment in 1980 that a small group of approximately 15 dedicated citizens visited the restaurant of a local Jewish man in Hayden Lake. His restaurant had been painted with swastikas and anti-Semitic graffiti. This citizen support for the restaurant owner included 5 local members of the Jewish community, 2 Protestant ministers, the Kootenai County prosecutor, and the Kootenai County undersheriff-elect, and the Kootenai County sheriff-elect, and a variety of local citizens. It was at this gathering that the idea was born for the Kootenai County Task Force on Human Relations. From this initial visit, this small band of human rights activists learned that any task force on human relations can only be as strong as the community perceives its support for victims to be. Ann Salisbury Brown and Jenny DeLong recount their early efforts to support the victims of malicious harassment.
The Kootenai County Task Force on Human Relations was originally a small band of citizens who came together to give moral support to those in the area who had been singled out as targets by bigots in the area. The original group gave personal and private support to victims. The most significant step in forging a strong image of victim support for the community was when members of the support group appeared in court with the victims when their tormentors went on trial.
A support group is the core of a new organization and must be quickly in place. Essential to its success is the availability of consultants in the legal field and in the handling of people in stressful situations. It is not necessary for the chair of this committee to have had training in these fields, but it is essential that the person can freely consult and call upon specialized resources. It is also helpful for the chair to attend some workshops at colleges or community centers regarding the effects of racism. Also helpful to have had experience to work with people of diverse backgrounds.
The objectives of the support group must be clearly set forth and faithfully implemented. We have 4 stated objectives. They are to be an ally of those who have been verbally or physically abused because of race, creed, or ethnic origin, to act as agents to prevent abuse in the community, to educate the community on the effects of bigotry, to provide a forum for those who desire to verbalize their concerns regarding racism and its effects on the individual and community.
To implement these goals, we have a loosely structured core group of about 5 people who brainstorm on the average of every 6 weeks to come up with ideas and programs meant to stimulate, educate, and actively involve other task force members. To involve other members, it has always been important to acquaint the community with our hands-on approach for victims. In the early days, we did this with the help of numerous concerned citizens. One, a reporter for a regional newspaper, through his coverage of the task force activities, made the public aware of the existence of the support group. The social services department of the hospital, libraries, churches, the college, supermarkets, and local businesses let us use their facilities to spread information about our group and our phone number. The head of public relations at the college arranged to have business cards for us at no charge. The Kootenai County Sheriff Department was also helpful in notifying the support chair of those in need of a call. Some victims preferred to talk only by phone, while others desired both a phone call and a follow-up visitation.
Not everyone contacted wanted to participate in all programs, and some contacts preferred not to participate at all. Some contacts were angry that we did not see the need and act sooner. The task force policy is to make an effort to let every victim know his or her legal recourse and what moral support is at hand. It is not always possible to know of incidents, as many are not reported and some are only rumor. However, we believe it is far better to act and be rejected than it is to miss making a contact.
We have learned a great deal about being a support group for victims of harassment. Our program has been one of trial and error, and in no way does the support group attempt to counsel. If counseling seems appropriate, the group directs the person to the proper resources. Our primary goal was and continues to be open and available for those who are hurting and labeled different, caught by the fear, insensitivity, or hatred of another human being.
The first 2 years of the task force were largely devoted to the creation of the Victim Support Group and to passage of anti-malicious harassment legislation. Also during this time, the task force struggled with an identity crisis of sorts. Not everyone involved in the task force wanted to be a visible means of support for victims. Others wanted to take a very active role, proposing legislation, staging rallies. Still others wanted to directly confront their opponents at every opportunity. The community itself was divided on its ideas of what to do. One school of thought promoted doing nothing, on the theory that if you ignore them, they'll go away. Even local government was opposed to any active stand proposed by the task force. Finally, after many bitter debates, the task force reached a crucial decision. They would go public, and they would go public with a very life-affirming, positive stand. That decision is clearly reflected in the slogan of the task force. Saying yes to human rights is the best way to say no to prejudice. Dina Tanners, a member of the local Jewish community and an activist, put that slogan into action with her work on the anti-malicious legislation. She, along with Reverend Rick Morse of the First Christian Church and first president of the task force, is credited with creation of the task force itself. Here she describes their early legislative efforts.
When we first began, we realized a lot of people felt powerless because they did not know how to deal with the serious problems in the area. We decided to create an organization where people could work together proactively. In those first 2 years, 1981 and 1982, our efforts went toward victim support and toward the passage of a state anti-malicious harassment law. To obtain passage of the bill, I organized a petition drive in support of the bill. It turned out to be very successful. The drive produced a great amount of public and media attention and the support of political leaders and organizations. Kootenai County Prosecuting Attorney Glenn Walker assisted in drafting the legislation, and Kootenai County Undersheriff Larry Broadbent organized the support of law enforcement across the state. The campaign was greatly boosted by the creation of a statewide organization known as the Idaho Coalition Against Malicious Harassment. The state organization was put together by Boise political activist Gail Spicer, who presently serves as chair of the Idaho Human Rights Commission. The coalition, with the support of the task force, pulled together over 100 religious, business, civic, political, and human rights groups in support of the legislation. Ms. Spicer organized telephone calls, letter writing, resolutions, and lobbying groups with excellent media coverage. These events resulted in the passage of the bill on March 30th, 1983. A combination of well-organized campaign by the Idaho Coalition Against Malicious Harassment, the Kootenai County Task Force on Human Relations, and the mistakes of the Aryan nations produced a victory for human rights. Following the enactment of the anti-malicious harassment law, there was a significant reduction in the number of incidents of harassment, graffiti, and hate materials.
Even before passage of the anti-malicious harassment bill, the community Stand Against Hate groups made front-page news with the arrest of former Aryan Nations member Keith Gilbert on harassment charges. Those charges stemmed from acts and threats against Scott Wylie, then an 18-year-old member of a multiracial family residing in Coeur d'Alene. Recalling those days is Dana Wetzel, who was then Deputy City Attorney for the City of Coeur d'Alene.
On March 8, 1983, Scott Wylie made a report to the Coeur d'Alene Police Department alleging harassment by a person named Keith Gilbert, who was a member of the Social Nationalist Aryan People's Party of Post Falls, Idaho. 2 days later, Scott met with me, and he brought his mother, Connie Fort, to see if I would proceed and prosecute the case. At that time, Scott was 18 and very much afraid. His mother, Connie, was tearful but very determined. The two of them related the following incident.
Scott Wylie is walking home from school in February 1983 when a white van approaches him. The white van slows its regular speed of travel and continues to travel towards Scott at the same pace that Scott was walking. Scott looked over at the van and sees Keith Gilbert through the open passenger window of the van. Mr. Gilbert turns and says to Scott, "Your life is condemned, and you shall be served in front of the devil. You have betrayed your race to conceive niggers, and your time shall perish. Thou dost not come forth to my life." Scott becomes very afraid when he hears these words. The van speeds up, goes down a block, turns right, and disappears. Scott turns around and runs to an adjoining house. He knocks on the door, is allowed into the house, and he calls his mother. A second incident takes place when Scott is returning home by bicycle from playing a softball game. Into view comes the same white van, again traveling towards Scott. Scott looks over at the van and again sees Keith Gilbert through an open passenger window. Gilbert leans out and says, "How are thee? Thou shalt not live long." Scott takes a shortcut through the parking lot and goes immediately home. As soon as he gets home, he tells his mother about the incident. Scott and his mother go to the Coeur d'Alene Police Department to make a report of the incident of malicious harassment.
This was not the first report that Scott's family had filed with the Coeur d'Alene Police Department and prosecutors. Up until a meeting with Scott and me, this was the first case that had ever been prosecuted. Prosecutions had not been pursued, largely because the problem had not been perceived as a large problem in our community, and because the incidences that were alleged were always incidences with just one person involved, where witnesses would be hard to find to verify the facts, or the victims were small children, so that testimony in court would be difficult to predict. However, in this case, on March 10, 1983, I determined to go ahead with prosecution. I decided to prosecute based largely on the demeanor of Scott Wylie. He would make a good witness. At 18, he appeared to be both sensitive but sensible. And it was obvious that he was very frightened from the incidences that had occurred. From the facts in the case, it was also very obvious that the act had been made to make him frightened. And to me, that was against the law. The case took a considerable amount of research and time to prepare. During that time, the early members of the task force provided help and assistance in gathering facts surrounding the case. They also provided a lot of support and motivation to all of us involved in the case. And they were able to provide some information on Keith Gilbert that I otherwise would not have been able to find. And that information was useful, and some of it was used in trial. The trial was held on October 24th, 1983, in Courtroom 6 of the Kootenai County Courthouse. It was a jury trial. 6 members of the jury were chosen from a panel of ordinary citizens from Kootenai County. On the plaintiff's side, with Scott and I, sat Scott's mother, Connie Fort, and 2 women from the Kootenai County Task Force. They sat close together for support, and they listened intently to the testimony and to the arguments being presented. On Keith Gilbert's side of the courtroom sat 4 or 5 large men dressed in military wear, and they sat separate, watching closely the people in the courtroom as well as listening to the testimony. The testimony was presented by Larry Broadbent, Scott Wylie, Connie Fort, and 2 students from Gonzaga University who had been interviewing at the Aryan Nation compound and were able to relay statements that were made at the compound about the Scott Wylie case. Keith Gilbert had been charged with 2 counts of verbal assault, both misdemeanors. The first count was based on the first incident, and the second count was based on the second incident. After about 3 hours of deliberation, the jury came back in with a verdict. They found Keith Gilbert innocent on the first count, and they found him guilty on the second count. It took a great deal of courage for the Kootenai County jury to convict Keith Gilbert of harassment. They could have easily found him not guilty. There had been no other cases, to my knowledge, that had ever been tried in Idaho under the verbal assault statute. In fact, there were no other states in the Union except Florida that even had that statute. Because Scott was the only person that could testify as to the events, and there were no other witnesses to verify his statements, it would have been very easy for the jury to find Keith Gilbert not guilty. It was really the courage and the conviction of the ordinary citizens of Kootenai County that brought harassment to the forefront in that courtroom on October 24th, 1983. The judge later pronounced sentence on Keith Gilbert, and it was one of the harshest sentences ever given for a misdemeanor in this county. The judge sentenced Keith Gilbert to 75 days in jail and a $50 fine. Keith Gilbert reported to jail and served all 75 days without repentance. The Keith Gilbert trial was significant not only because it convicted Keith Gilbert of harassment, an act in which he had been engaged for over 2 years in Kootenai County, but that trial sent an important message to the Aryan nations that the law enforcement agencies and the prosecutorial arm of the courts were no longer going to quickly review and reject cases based on harassment. And even more important, the trial sent a message to the Aryan nations that the ordinary citizens of Kootenai County were not afraid to convict people for harassment. But the lesson to be learned from the Keith Gilbert trial is that the first line of defense, law enforcement agencies and prosecutors, are not always the best defense, the best agencies to provide defense to harassment cases. Prosecutors are often hesitant to take these types of cases to trial because the law makes it difficult to prove the case. Also, typically, these types of harassments take place when the victim is alone and there's no way to really independently verify facts. Because prosecutors are hesitant to take cases, it's often very important for people involved to pursue prosecution. Prosecutors are often hesitant to take a case until they feel that the people on the jury in their jurisdiction are ready to bring back a conviction based on the facts. Kootenai County is a good example. Harassment incidences had been occurring for over a year before the Keith Gilbert prosecution was actually taken to court. Had it not been for the determination of Connie Fort and her efforts to proceed and attempt to convince the law enforcement agencies and the prosecutors to take these cases, and had it not been for the support of the early Kootenai County Task Force members, the Keith Gilbert case most probably would have not gone to trial. The case is also a good example that you can prosecute harassment based on common laws that you have in your statutes, assault and battery. Later in Idaho, other statutes were enacted, but that was before the Keith Gilbert case. This case clearly shows that you can use the law that you already have in your state to be successful and convict people of harassment.
In March of 1986, a man named Larry Floyd Phillips arrived in Coeur d'Alene asking directions to the Aryan Nations compound. 5 months later, he accosted a black man in the local Kmart. He made racial slurs, pushed a shopping cart into him, and hit him with his fist. He was charged with a felony crime of malicious harassment, and he ultimately pled guilty. He was placed on probation and later moved out of state. It was the first time the new Malicious Harassment Act was used. It was a tough new law, and it made a difference.
With what we just finished was the years 1980 through 1983 of the Kootenai County Task Force on Human Relations, their work in human rights here in the Northwest. On the program next week, program number 3, we'll look at the years 1984 through 1986 of the work of this human rights organization. And again, I want to remind you that both programs 2, 3, and 4 were taped 14 years ago. I hope you enjoy our program next week.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station.